what I gather from this bail, wishing for bail and to basically grant Combs bail and restart another trial of a different meaning, because there's elements to the case that is very vague. And Combs at the time was talking to victim 2 without realising that victim 2 was talking to the government and things like that. But this was November 2024. In January 2025, victim 2 decided to go with the government, and instead of Combs, he was still paying for her flat. He was still paying for her solicitor, a lawyer, and I feel there's an element of domestic abuse to this. That the man's vile. He should be let go, given bail, and then to do a retrial of abuse. Now, the RICO charge, it just is a sham, really. I mean, I feel like the government have restricted Combs' access to his lawyer and to elements like that, which doesn't help the proceeding moving forward. It's not given clear basis of victim 2. I believe victim 2 may not be a victim. I will leave that for the judge to decide that, and the jury. But there's elements to this that the government aren't meeting the right criteria to go and make federal charges towards Combs. I would like to know what you think. What do you think on the case so far? Do you feel like it was an anticlimax, the evidence and the docket moving forward? Because I heard some horror stories about Combs, and it seems that he is an undesirable, but he's not, I would say, a trafficker. It's a very strong statement. He has issues with his sexuality, and I think a lot to do with his voyeurism, and you've got to take accountability to some degree. This lady is older than Cassie. I can't see Cassie being groomed and stuff like that, but you've got to admit, you've got to come to a point where you take accountability. You can't just pop a pill in her mouth, and next thing she's doing things she wouldn't normally. That is something that she has to sort out in therapy, but I'm not judging her. I do feel he treated her atrociously. He treated all of them atrociously, even his staff, You have to take accountability. You have to complain and put these people in their place. Giving a life sentence is a serious, serious part of this. And I'm not sure if he deserves a life sentence, for this. But it would be prudent to give him bail and then set another thorough deep investigation first, because it seems like it's making the government look bad, and even if it's not trying to, it's sort of giving elements of corruption. And I'm reading this, and I do think Shapiro has a very valid point. He's an excellent lawyer, and I'm grateful he points these points out. And that's all for me anyway. Take care, everyone. Promote peace. Promote always victims first. And stay safe. Take care. Bye-bye.
Welcome to another episode of the Diddy Diaries. As we await Diddy to hit the courtroom for his next bail appearance, we're going to take a look at the reply memorandum in further support of Mr. Combs' renewed motion for bail. And this is the motion that we were just discussing in the last episode. So, let's dive right in. Case number 24-CR-542, United States of America for Sean Combs. Reply memorandum in further support of Mr. Combs' renewed motion for bail. Introduction. The government persuaded Judge Carter to detain Mr. Combs, claiming its video of an 8-year-old incident was evidence of sex trafficking, and by making unsubstantiated claims of witness tampering. The defense rebutted those arguments through its own proffer, but lacked access to key evidence that could corroborate its rebuttal. Nearly 2 months later, much has changed. Most importantly, discovery produced after the initial bail hearing, some of it after this motion was filed, shows the narrative that the government presented then was fictional. For instance, we now know that even before it arrested Mr. Combs, the government possessed, redacted, confirming his account of the March 5th, 2016 incident at the Intercontinental Hotel. But instead of presenting that video to the court, the government submitted an altered video that omitted key scenes and presented events materially out of order. The prosecutors also claim that there was a second victim, but they have never interviewed her, and messages produced in discovery confirm she was not a victim. Likewise, communications produced in discovery show Mr. Combs' contacts with witnesses were innocuous and consistent with his right to participate in his defense by developing potential defense witnesses. The government's opposition brief confirms that bail should be granted. It spills much ink, insisting the court lacks authority to reopen the bail proceedings, even though the controlling authority clearly establishes the court's ample discretion to do so. The government also offers no response to many of the cases cited in Mr. Combs' motion, including 2 other sex trafficking cases in which bail was granted: United States v. Jeffries, 24-CR-423, NJC, EDNY, and United States v. Fox, number 22-10432022, WL 25-64-600, 2nd Circuit, July 8, 2022. Instead, the government reprises the same disingenuous tactics it used the prior proceedings. It took full advantage of the detention order, scouring Mr. Combs' communications to try to find some actual evidence to substantiate its obstruction allegations. But once again, the government's theatric spin on the evidence omits key context and creates a misleading picture. For instance, it makes much more of Mr. Combs' contacts with others, but is unable to point to any communications involving actual tampering efforts. And it omits key parts of conversations which show that Mr. Combs was not pressuring anyone or telling anyone what to say about anything. Likewise, its allegations about MDC rule violations are false or overblown. There's no legitimate legal basis for continuing to force Mr. Combs to prepare for trial from jail. The government is unable to show that the extremely restrictive proposed conditions are insufficient to prevent any possible danger or obstruction. The revelations about the recent MDC raid only confirm that it is impossible for Mr. Combs to work with his counsel on a confidential basis to develop his trial strategy from jail. He is entitled to pretrial release under the Bail Reform Act and the Constitution. The argument: the court should exercise its ample discretion to reopen the bail hearing. Mr. Combs' motion presents new material information. The government's efforts to disparage the significance of the new evidence supporting Mr. Combs' motion are nothing more than empty rhetoric. The evidence cited in Mr. Combs' motion fundamentally undermines the government's prior representations as to the weight of the evidence and the nature and seriousness of the purported danger that he presents. U.S. Code 18, Section 3142, G2 and 4. That is more than sufficient to demonstrate changed circumstances, which is satisfied by showing the strength of the primary evidence relied upon by the government to demonstrate danger has been undermined by new information. United States v. Stevens, 447, F.SUPP 3D, 6364, SDNY 2020. The specific evidence outlined in Mr. Combs' motion was not available at the time of the initial hearings. Although the defense had a general understanding of Mr. Combs' past interactions with individuals like Victim 1, we did not have access to specific contents of relevant correspondence because it was contained on devices that were seized from Mr. Combs but had not yet been produced to him. Thus, the government's claim that nothing about the content of the text messages between the defendant and Victim 1 were unknown to him at the time of the initial hearing is false. The government does not dispute that other evidence, such as the redacted, could not have been known to Mr. Combs during the initial hearings. In one example, Mr. Combs did not know that redacted and redacted directly contradicted the government's claims at the detention hearings. Nor did Mr. Combs know that the government was portraying a second woman as a purported victim, even though it has never even spoken to her. This is sufficient new information to reopen the hearing. See United States versus Jones, 583 F.SUPP 2D, 513 SDNY 2008. New documentary evidence that called into question grand jury testimony sufficient to reopen a bail hearing. The government's separate argument that the court has no inherent authority to reopen the hearing because this case has been designated or reassigned is baseless. The court is entitled to consider the basis for the detention order in deciding whether to reopen. We're not asking the court to rule that Judge Carter erred, which is what United States v. English addressed when it observed that a second district judge is not authorized to review the decisions of a previous district judge, 629 F.3D 311 320, 2nd Circuit, 2011, interpreting review in the bail appeal statute, U.S. Code 18, Section 3145. We are simply offering new evidence and additional conditions in response to the reasons Judge Carter gave for detaining Mr. Combs. As the Second Circuit is clearly instructed, the Act leaves the decision to reopen a hearing to the sound discretion of the District Court. United States v. Zong, 55 F.4th, 141-148, 2nd Circuit, 2022. And a prior detention determination is a natural reference point against which to measure the materiality of new information for the purpose of reopening the hearing. Indeed, to suggest otherwise would nonsensically untether the materiality inquiry from those facts that the court found consequential to its earlier detention decision. B. Since filing his motion, Mr. Combs has received even more new material information demonstrating the government misled the court about the video at the prior bail hearings. On November 13, 2024, the government produced even more material new evidence, including more redacted, of the March 5, 2016 Intercontinental Hotel incident. The government had this redacted as early as August 7, 2024, yet only produced it to the defense after Mr. Combs filed his renewed motion for bail. Garagos declaration at 41 through 44. The redacted consists of redacted, Garagos declaration examples B and C. Redacted used to create the government's principal piece of evidence at the earlier bail hearings, an edited, manipulated version of the video published by CNN. The new redacted supports the defense argument at the earlier bail hearings and shows the government knowingly mischaracterized and concealed critical facts during those hearings. As an analyst prepared by forensic video analyst Connor McCourt, Garagos Declaration Example D explains, the video the government submitted to the court omits footage corroborating the defense account, changes the sequence of events in material respects, and does not accurately depict the events. The government had the more complete redacted during the initial hearings, but chose not to share it with the court. Instead, it offered its edited version of the CNN video as its most powerful evidence of danger and obstruction. Mr. Combs argued Exhibit A1 was not evidence of a freak-off, but depicted a domestic dispute in which he ran down the hall of the hotel to recover his clothes and his cell phone. The government invented a different narrative. It argued our evidence will show that's just not what happened, because if it's about the clothes and wanting to get the clothes back, which again it's not, why drag the victim back down the hall to the room? And you see that on the tape. That's what he does. 9/18/24, TR 12. The government further argued that Mr. Combs throws a Voss at her, ID TR 10, which the district court cited in detaining Mr. Combs, ID TR 49. The government apparently stands by those arguments again here, but they are false, and the government knows it. The more complete footage of the incident, in contrast to the government's sensationalized CNN cut, contradicts the government's representations. The video demonstrates that 1. Mr. Combs, in fact, ran down the hall to retrieve a bag of clothes and a cell phone. 2. He did not drag victim 1 back down the hall to the room, as the government and its resequenced exhibit falsely suggests. 3. He did not throw a vase at victim 1, but only its contents, presumably flowers. And 4. She was not only able to leave once security staff intervened, ID TR10, see Garagos declaration examples B, C, and D. In other words, it is the government whose explanation is just another cover-up, just more lies. 918-24 TR12. The true facts corroborate what Mr. Combs has stated all along. The video is not evidence of a coerced freak-off and sex trafficking, but rather a sad glimpse into a decade-long consensual relationship between Mr. Combs and victim number 1. All right, we're going to wrap up episode 1 right here, and in the next episode, we're going to pick up with C. The new evidence undermines the government's initial proffer. All of the information that goes with this episode can be found in the description box. What's up, everyone, and welcome to another episode of the Diddy Diaries. In this episode, we're picking up where we left off with a memorandum in further support of Diddy getting bail. C. The new evidence undermines the government's initial proffer. Mr. Combs' new evidence undermines the basis for the initial detention decision, and none of the government's more specific arguments demonstrates otherwise. Communications with victim 1 do not evidence sex trafficking. Not one piece of correspondence that we have reviewed between Mr. Combs and victim 1, the sole victim in the indictment, corroborates the prosecution's sex trafficking theory or its representations at the previous bail hearings, and the government still does not offer a single piece of actual evidence supporting that allegation. Instead, it reiterates its proffer of cherry-pick citations to purported messages, see docket 69 at 7. If the messages in context actually supported the government's argument, why hasn't it produced them to the defense or provided them to the court? The government brushes off victim 1's motives for accusing Mr. Combs as having no bearing on the question of bail, docket 69 at 8. But victim 1 is the only victim identified in the indictment, and her credibility will be a, if not the, key issue at trial. If the jury does not credit her testimony, it will have to acquit him of sex trafficking count. Her motives thus directly relate to and diminish the weight of the evidence against Mr. Combs, as well as the nature and seriousness of the purported danger that he presents. U.S. Code 18, Section 3142, G2, and 4. 2. There is no second victim at all. The government does not even dispute that despite labeling a second person a victim of sex trafficking, it has never even spoken to her. Presumably, for this reason, the government also fails to dispute the fact that 1. This individual was voluntarily intimate with Mr. Combs for years, 2. Redacted, and 3. Redacted. The government now falsely portrays as sex trafficking. The government simply has no response to these facts. Instead, it doubles down on more misleading misrepresentations to the court. It suggests Mr. Combs is tampering with this individual through financial coercion, including as recently as mid-September 2024, docket 69 at 9. Yet the government knows, but again withholds from the court that, redacted, there is simply no financial coercion at all. 3. Mr. Combs did not obstruct grand jury witnesses. The government's discussion of Mr. Combs' contacts with witness 1, docket 69 at 9 and 10, contain no facts suggesting any tampering. The government does not and cannot dispute Mr. Combs did not try to influence the individual's grand jury testimony. To the contrary, he confirmed the witness should be redacted. Docket 61 at 13. Indeed, his contacts with the witness were in coordination with counsel and in connection with defense investigation. Garagos Declaration 12 through 23. The government cites 128 phone contacts in total with witness number 2, docket 69 at 11, but ignores that the content of the correspondence evinces no obstruction. The most the government can offer is that redacted, redacted, and redacted. That is all, and it is not evidence of obstruction. D. U.S. Code 18, Section 3142, further warrants release. The government concedes that in considering whether release is necessary for preparation of the person's defense, the Bail Reform Act requires that a defendant in custody be afforded reasonable opportunity for private consultation with counsel. U.S. Code 18, Section 3142, I3, Docket 69 at 14. The government's breezy assurance that MDC's procedures do not infringe on the defendant's constitutional right to effective counsel or to participate in his defense, Docket 69 at 14, is cold comfort, particularly given what the opposition revealed about how the government has taken advantage of the detention order to violate Mr. Combs' privacy and pierce his privileged communications with his attorneys. The government has 1. Listened to his calls, including with family members and attorneys, and 2. Reviewed messages, including with dozens of individuals, including attorneys. ID at 18. The BOP sweep and prosecutor's conduct here will unquestionably have a chilling effect on Mr. Combs' preparations if his detention continues. The government's response that its actions need only be reasonable, not perfect, Docket 72 at 5, provides little comfort. CF Stevens, 447 F SUPP, 3D at 67. BOP suspension of visits and calls impacted the defendant's ability to prepare and created obstacles in attempting to communicate with counsel, making release necessary for preparation of defense. Defense counsel has repeatedly tried to come to an agreement with the government on various issues, including the sharing of discovery with Mr. Combs and clarifying the filter team's protocol. These issues remain unresolved. The government says it will provide laptop in short order, Docket 69 at 15 and 5, but it has been saying that all along. And while it's made a laptop for counsel to bring into the MDC available this week, it has still not provided a laptop for Mr. Combs to have in the facility. The government has done nothing to remedy the issue raised by the motion. To the contrary, it hid from the defense that Mr. Combs' privileged materials and work product were searched and seized. The comment that it stands ready to engage with defense counsel on the issues if needed, Docket 69 at 15 and 16, is hard to take seriously given the history here. Nor is the suggestion, Docket 69 at 15, that Mr. Combs should consent to further delaying the trial if detention makes preparation impracticable. He has constitutional and statutory rights to a speedy trial. When the government moves for pretrial detention, it has an obligation to arrange for the trial as quickly as possible, using extraordinary means if necessary. United States v. Jackson, 823 F.2D, 4-8, 2nd Circuit, 1987. Indeed, Jackson makes completely clear that the court will not view this obligation of the government lightly. 2. The government's new evidence does not justify detaining Mr. Combs. A. Mr. Combs' use of Contact Me ASAP, other PAC numbers, and three-way calling is not an attempt to evade law enforcement. Mr. Combs' use of methods of communication that the government claims violate BOP policy does not evidence obstruction and does not justify detention. It's simply not true that the communications are designed to evade BOP and law enforcement monitoring. ContactMeASAP.com is a service that defense counsel did not believe was unauthorized by BOP, as it's widely used in the prisons. Garagos, Declaration 36 and 38. Defense counsel has spoken multiple times with administrator of this website to confirm that the method of communication, 1, utilizes BOP's TrueLink system, which it does, and 2, is monitored by BOP officials, which it is. The government, therefore, can read and even block every single message Mr. Combs sends and receives through this service, as was Mr. Combs' understanding. Indeed, the government has never once instructed defense counsel to have Mr. Combs refrain from using the service, nor has the BOP. Mr. Combs is no longer using ContactMeASAP.com as of November 16, 2024. The use of other inmates' PAC numbers is also widespread practice at the MDC and not obstruction. Inmates routinely share their calling minutes with other inmates, and they are limited to 15 minutes per call and 1 call per hour. The government has presented no evidence suggesting anything Mr. Combs says using other numbers is any different from what he says while using his individual PAC number. If anything, that Mr. Combs needs to resort to sharing minutes demonstrates that the conditions at MDC do not permit an adequate defense preparation. Although this is technically not permitted by BOP policy, the BOP effectively sanctions the practice, and the calls are monitored. The government claims to have reviewed multiple calls in which Mr. Combs has attempted to dial in third parties, but it does not describe how any of those calls could be attempts at obstruction. And while it states that the potential contacts in these calls include members and associates of the enterprise, ID, because the government will not identify these individuals, the defense has no way of testing the government's claim. Indeed, redacted. See Docket 69, Example H at 1053. B. The communications do not evidence obstruction. The messages cited by the government reflect Mr. Combs' efforts to investigate and prepare his defense, including, with counsel's participation, nothing more. Redacted, Docket 69 at 21. Redacted, Docket 69, Example M, at 3:30 and 4 minutes. And at the time, the defense team did not even know that this individual was a purported victim. Garagos Declaration 6 through 11. Redacted, Docket 69, XN at 4:16. Redacted, ID at 5:17 and 5:30. Of course, the government continues to portray the individual in question as a victim who could provide powerful testimony against Mr. Combs, Docket 69 at 21. Mr. Combs' Sixth Amendment rights would be violated if counsel did not adequately conduct a thorough investigation into the individual, and any such investigation must be based, quite properly, on informed strategic choices made by the defendant and on information supplied by him. Strickland v. Washington, 466 U.S. 668, 690, 1984. Indeed, what investigation decisions are reasonable depends critically on such information. Accordingly, courts are mindful of a pretrial detainee's need to make telephone calls to potential witnesses and other individuals who might be useful to the defense. United States v. Persico, number S84CR809, JFK, 1986, WL 3793 at 2, SDNY, March 27, 1986. Mr. Combs' comments to that effect do not evidence obstruction. The government completely mischaracterizes the content of redacted on Exhibit L, redacted Docket 69, Example L, at 133, redacted ID at 138, redacted Garagos Declaration 2526, redacted Docket 69, Example L, at 152 through 159, redacted. The music video for which was never released, ID at 213. Garagos Declaration 27 through 30. The quotes cited by the government tellingly include no reference to Victim 1 because there aren't references to any videos or public relations strategy meant to discredit her. See, Mr. Combs' other comments reflect protected First Amendment speech. The government also cites comments reflecting classic protected speech. The government claims using public statements to alter public perception and redacted is obstructive. Docket 69 at 19. It argues the same regarding establishing a narrative about redacted, Mr. Combs' belief that this is redacted, and his persona as a redacted. ID at 19 and 20. Without question, a pretrial detainee does not necessarily forfeit his or her First Amendment rights. United States v. Marotti, number 507 CR 0428 DEP, 2008 WL 687, 434 at 4. NDNY, March 11, 2008. Indeed, as the Supreme Court has held, in some circumstances, press comment is necessary to protect the rights of the accused because the defense does not begin inside the courtroom door, and one cannot ignore the practical implications of a legal proceeding for the accused. Gentile v. State Bar of Nevada, 501, U.S. 1030, 1042, 1058, 1991. The cited conduct does not demonstrate any real or specific threat to the legal process, and Mr. Combs' statements have the full protection of the First Amendment, ID at 1058. Gentile considered the appropriate standard for speech restriction on a lawyer, but Mr. Combs, who is a criminal defendant and presumed to be innocent, has a greater constitutional claim than other trial participants to criticize and speak out against the prosecution and the criminal trial process that seek to take away his liberty. United States v. Trump, 88, F.4th 990, 1008 D.C. Circuit, 2023. His comments, which were not even made but merely anticipated, involved thoughts that his prosecution is politically motivated or that he is innocent of the charges against him, which would constitute protected speech. To the extent the court remains concerned that such statements might interfere with a fair trial, the remedy is not to detain the defendant, which would chill free speech. Instead, it is to screen potential jurors through voir dire. Moreover, the Bail Reform Act authorizes courts to release pretrial detainees on conditions that they avoid all contact with an alleged victim and with a potential witness. U.S. Code 18, Section 3142, C1 BV, which mitigates the specific obstruction concerns raised by the government. 3. The government cannot meet its burden to continue detention. A. There's no clear and convincing evidence supporting detention. The government claims its detention request is supported by witness testimony, communications, photos and videos, police reports, and other materials. Docket 69 at 22. But it has produced no such evidence, only testimony, and the bail record confirms that redacted. Docket 61 at 13 and 14. The communications it continues to rely on include innocuous messages sent by purported victim number 2, docket 69 at 9. An individual the government has never spoken to, and one it knows isn't a victim, docket 61 at 12. And its piece de resistance, the video involving the only specific victim mentioned in the indictment, is not evidence of sex trafficking as explained, see supra, point I and B. The government again reiterates the indictment's allegations, docket 69 at 22, but offers no response to the case law, illustrating why those allegations are insufficient to meet its burden. B. There is no risk of flight. Mr. Combs fully intends to face these charges. The prospect of a conviction does not materially change his incentives here, where his reputation has already been destroyed by the government's allegations and aggressive and deceptive media tactics, and can only be rebuilt by winning at trial. As the government concedes, Mr. Combs took steps to mitigate the risk of flight before the indictment, docket 69 at 24. And there's no credible risk that he will attempt to flee if committed to 24/7 custody of qualified security personnel. C. The proposed bail conditions are sufficient. The proposed conditions specifically mitigate any possible concerns. The government cites purported obstruction carried out through phone and email, but under the proposed conditions, Mr. Combs will have less access, in fact no access, to such means of communication other than to communicate with counsel. Moreover, family visits will require prior approval, and Mr. Combs would consent to security personnel monitoring the visits and video monitoring if necessary. Tellingly, the government does not even attempt to distinguish the precedent supporting release on comparable conditions in similar cases. See docket 61 at 5 and 6. Indeed, the government consented to release on conditions of 2 defendants in the Jeffries case since the initial bail hearings here. The government is also wrong that United States v. Bustani 932 F.3D 79 2nd Circuit 2019 favors detention. As explained in Mr. Combs' reply on appeal, which he incorporates here, see United States v. Combs, number 24-2606, 2nd Circuit, docket 35 at 9 and 10, Bustani stated a private security arrangement may be appropriate where the defendant is deemed to be a flight risk or danger, primarily because of his wealth. 932 F.3D at 82. That is exactly what the government has argued and alleged in this case. Docket 69 at 9. Citing financial coercion and significant financial benefits, ID at 24, arguing that Mr. Combs has nearly limitless resources to facilitate his flight. Indictment alleging racketeering activity fueled by employees, resources, and influence of Mr. Combs' multifaceted business empire. Bustani cannot foreclose release, where the government repeatedly emphasized the defendant's wealth in explaining the risk of flight. United States v. Weigand, 492 F.SUPP 3D, 317 319 SDNY 2020. Accuracy of its proffers are in question. They should be disregarded, and the court should only rely on the underlying evidence or evidentiary sources. United States v. Martyr, 782 F.2D, 1141, 1147 2nd Circuit, 1986, according to United States v. LaFontaine, 210 F.3D, 125, 121, 2nd Circuit, 2000. Conclusion. For the foregoing reasons, the court should reopen the hearing and grant bail on the proposed conditions or on any other conditions that the court deems appropriate. Respectfully submitted, Alexandra A.E. Shapiro. And this was dated November 21st, 2024. All of the information that goes with this episode can be found in